non-performing assets, insolvency, bankruptcy, liquidation. Have you heard of these terms before? I hope most of us have a good idea of these terms. But today, let's have a better understanding of each of these terms with a special focus on the Insolvency and Bankruptcy Code of India, that is IBC.
A non-performing asset refers to a classification for loans that are in default, or when the lender considers the loan agreement to be broken and the debtor is unable to meet his obligations. Insolvency is when a company can no longer meet its financial obligations to lenders as debts become due. It can arise from poor cash management or an increase in expenses. Bankruptcy is a legal proceeding involving a business that is unable to repay its outstanding debts. All of the debtor's assets are measured and evaluated, and those may be used to repay a portion of the outstanding debt. Liquidation is the process of bringing a business to an end and distributing its assets to its claimants. It usually occurs when a company is insolvent. The remaining assets are used to pay the creditors and shareholders based on the priority of their claims. Let's assume a bank has given a loan of 1 crore rupees to a company for a period of 5 years. The company was able to fulfill its payments till the second year. But then, due to economic slowdown, the company was unable to generate enough cash to repay the loan interest. After a period of 90 days, this account will be considered an NPA account by the bank. The condition which the company is facing is known as insolvency. And if the bank follows legal proceedings to recover its dues from the company, it will be called bankruptcy. If the bank is unable to recover its dues, then as a final option, it can ask the company to sell off its assets to recover its dues. This process will be known as liquidation. Most of us must have heard about the ease of doing business rankings. As per the 2015 rankings, before the IBC came into existence, India's insolvency ranking was 137, much behind the nations like South Africa, Russia, and Brazil. Only 25.7 cents of a dollar were recovered in such cases, as compared to 90 cents in Singapore and around 87 cents in Canada. It used to take around 4.3 years to resolve any corporate insolvency case in India, as compared to 1.5 years in USA and 1 year in UK.
I hope by now you all have a good idea about NPA, insolvency, bankruptcy, and liquidation. We have also seen how was the scenario of insolvency resolution in India as compared to the other nations in 2015. Now let's move forward and talk about Insolvency and Bankruptcy Code of India. IBC came into existence in May 2016. In the second part, let's see what are the components of the code, how is the process takes place, and how has been its performance in the last 4 years.
The first component is Insolvency and Bankruptcy Board of India. It is the apex body for promoting transparency and governance in the administration of the code. It is involved in setting up the infrastructure and authorizing insolvency professionals and information utilities. The second component is information utilities, which are the centralized repository of financial and credit information of borrowers. Then comes insolvency professional agencies, which are professional bodies registered by the board to promote and regulate the insolvency profession. Next is insolvency professional, who is a licensed professional regulated by the IBBI. He will conduct the resolution process and will act as the liquidator. He is appointed by the Committee of Creditors and will assume the power of the Board of Directors. The adjudicating authority would be the National Company Law Tribunal to entertain or dispose any insolvency application and decide in respect of claims or matters of law. The final component is the Committee of Creditors. It consists of financial creditors who will appoint and supervise the actions of insolvency professionals, and they need to approve or reject the resolution plan. This structure will help us better understand how the various components are related to one another. The Insolvency and Bankruptcy Board of India is involved in setting up the insolvency professional agencies and information utilities. The insolvency professional agencies are responsible for regulating the insolvency professionals. The insolvency professionals and committee of creditors are in direct management of the insolvent entity. The NCLT acts as the adjudicating authority. Now let's move forward and try to understand the whole process with the help of a simple picture. The first step is when the creditors ask the NCLT to put the corporate debtor in corporate insolvency resolution process. The second step is when the NCLT agrees to take the case forward. Then the CIRP starts and an interim resolution professional is appointed. The interim IP then, with the help of information utilities, gather the information about the various creditors and creates the committee of creditors. This committee then selects the main insolvency professional who will manage the whole process. When a resolution plan is suggested, either the committee agrees to it or rejects it. If it agrees, then the insolvent company will get a revival in the form of a resolution plan. Otherwise, the same company will end up in liquidation. The timeline for this whole process is 180 days and can be extended by another 90 days. Let's now analyze the performance of the code from the time of its inception. In 2017, the Reserve Bank of India had shortlisted 12 large corporates for immediate bankruptcy proceedings, since these corporates together owed the banks a whopping 3.5 lakh crore rupees. These 12 firms collectively were famously known as the Dirty Dozen. There is one particular case which I like to mention, and that is of SR Steel. It owed the highest amount to the banks to the tune of 50,000 crore rupees. It took around 2.5 years of time, way above the deadline of 270 days to resolve this process. And finally, ArcelorMittal acquired this company for a whopping sum of 40,000 crore rupees. Broadly, 3,774 resolution processes have been initiated until the end of March 2020, according to the latest report from the Insolvency and Bankruptcy Board of India. Of these, 714 have ended up in liquidation and the resolution plans in 221 cases have been approved. This picture will help us in having more clarity of the performance of IBC till March 2020. With a few exceptions, the story of these years has been one of many legal battles. The powerful corporates have managed to indefinitely delay the corporate insolvency resolution process. To stop this, there have been some amendments made to the code. The first is related to that of the willful defaulters, who knowingly borrowed more than they could repay, or who are fraudulent promoters. They will not be allowed to be a part of the pool of potential buyers for a company being sold by lenders. In another significant move, there would be ring fencing of corporate debtor resolved under the IBC in favor of a successful resolution applicant from criminal proceedings against offence committed by previous promoters. Another major change to the bankruptcy law will enforce a strict 330-day timeline for the insolvency resolution process. We previously talked about the ease of doing business rankings in 2015, before the IBC came into existence. Now, let's observe the latest rankings of 2019. The recovery rate for creditors jumped from 26.5 cents on the dollar to 71.6 cents. And the time taken for resolving insolvency reduced significantly from 4.3 years to 1.6 years. As a result, the insolvency ranking, which was 137 in 2015, has continuously improved and reached a ranking of 52 in 2019. The World Bank recognized that through the code, companies have effective tools to restore financial viability, while creditors have greater chances to realize the money. This code has helped India in achieving the overall rank of 63 from 142 in 2015. When IBC came into existence, it was meant for non-finance firms, but now some of the financial services firms also came under the IBC. So you have to tell us which company became the first financial services firm to be taken to NCLT under the IBC. Please post your answers in the comments. We hope you will like the video. Please mention in the comments what did you like about the video. We will be back with more such videos.